Section 103. When importation begins and deemed terminated. Importation begins with a carrying vessel or aircraft enters the Philippine territory with the intention to unload therein. Importation is deemed terminated when A. The duties, taxes, and other charges due upon the goods have been paid or secured to be paid at the port of entry unless the goods are free from duties, taxes, and other charges and legal permit for withdrawal has been granted. Or B. In case the goods are deemed free of duties, taxes, and other charges, the goods have legally left the jurisdiction of Bureau. Section 4. When duty and tax are due on imported goods, except as otherwise provided for in this Act or in other laws, all goods when imported into the Philippines shall be subject to duty upon importation, including goods previously exported from the Philippines. Unpaid duties, taxes, and other charges shall incur legal interest of 20% per annum computed from the date of final assessment under Section 429 of this Act, when payment becomes due and demandable. The legal interest shall likewise accrue on any fine or penalty imposed upon payment of the duties and taxes and other charges. The Bureau shall issue the necessary receipt or document as proof of such payment. Section 5. Effective date of rate of import duty. Imported goods shall be subject to the import duty rates under the applicable tariff heading that are effective at the date of importation or upon withdrawal from the warehouse for consumption. In case of withdrawal from the free zones for introduction to the customs territory, the duty rate at the time of withdrawal shall be applicable on goods originally admitted, whether withdrawn in its original or advanced form. In case of goods sold at customs public auction, the duty rates at the date of the auction shall apply for purposes of implementing Section 1143A of this Act. Section 6. Declarant. A declarant may be a consignee or a person who has the right to dispose of the goods. The declarant shall lodge a goods declaration with the Bureau and may be A. This importer being the holder of the bill of lading. B. The exporter being the owner of the goods to be shipped out. Or C. Customs broker acting under the authority of the importer or from a holder of the bill. Or D. A person duly empowered to act as agent or attorney in act for each holder. In case the consignee or the person who has the right to dispose of the goods is a judicial person, it may authorize a responsible officer of the company to sign the goods declaration on its behalf. The goods declaration submitted to the Bureau shall be processed by the declarant or by a licensed custom broker, provided that for importation, a transition period of 2 years from the effectivity of this Act is hereby provided, during which subparagraph D of this section shall not be implemented by Bureau, provided for that after 2 years from effectivity of this Act, subparagraph D of this section shall take into the effect consistent with international standards and customs best practices. Section 107. Rights and responsibilities of the declarant. The declarant shall be responsible for the accuracy of the goods declaration and for the payment of all duties, taxes, and other charges due on the imported goods The licensed customs broker shall likewise be responsible for the payment of duties, taxes, and other charges due on the imported goods. The declarant shall sign the goods declaration even when assisted by a licensed custom broker who shall likewise sign the goods declaration. Section 108. Penalties for errors in goods declaration. The Bureau shall not impose the substantial penalties for errors when such errors are inadvertent and there was no fraudulent intent or gross negligence in the commission thereof, provided that in order to discourage repetition of such errors, a penalty may be imposed but shall not be excessive. Section 109. Applicable of Information and Communication Technology. In accordance with international standards, the Bureau shall utilize information and communication technology to enhance customs control and to support a cost-effective and efficient customs operation, geared towards a paperless customs environment. The Bureau shall communicate, exchange, and process trade and logistics related information in the national and regional level for the efficient and prompt clearance of goods, commodities, and a technology neutral and secured infrastructure for business, industries, and government. The security of data and communication shall be acceptable in and shall have the legal effective validity of enforceability as any order, document, or legal writing, provided that when the prescribed requirements are duly complied with, the Bureau shall a. Recognize the authenticity and reliability of electronic documents. B. Transmit approval in the form of electronic data message of electronic documents. And C. Require and or accept payments and issue receipt acknowledging such payment through systems using electronic data message or electronic documents. The introduction and the implementation of information and communication technology shall be undertaken with due consultation with directly affected practices and stakeholders. Section 110. Relationship between the Bureau and the third parties. Parties may transact business with the Bureau either directly or through a designated third party to act on their behalf. The custom transaction directly transacted by a party shall be treated less favorably or be subject to more stringent requirements than those transacted through a designated third party. A designated third party shall have the same rights and obligation as the designing party when transacting business with the Bureau, subject the provisions of existing laws, treaties, convention, and international agreement. The Secretary of Finance shall make the necessary guidelines for the defined relationship of the Bureau and the third parties. Section 111. Information of general application. All laws, decisions, ruling, circulars, memoranda, and order of the Bureau shall be published in accordance with law. To foster an informed compliance regime, the Bureau shall ensure that all relevant and available information of general application pertaining to customs operation and procedures which are not confidential or intended for the Bureau international use only, shall be readily accessible to any interested persons. Any information amended for changes in customs administrative procedure or requirements shall, as far as practicable, be made readily available prior to its effective date of implementation unless advance notice is precluded. Section 112. Information of a specific nature. The Bureau shall provide information not otherwise confidential or for the Bureau's international use only, relating to a specific matter as may be requested by an interested party for the legitimate use. The Bureau may require the payment of a reasonable fee in providing such information. The requested information shall be released within reasonable time for filing of the request and payment of the required fee. Section 113. Decisions and ruling. The Bureau shall, consistent with Section 1502 of this Act, issue binding and advance decision and ruling at the request of an interested party on matters pertaining to importation or exportation of goods. Upon written request of the interested party, the Bureau shall notify the party of its decision in writing within the period specified in this Act or by regulation. Should the decision be adverse to the requesting interested party, the reason thereof shall be indicated, and the party shall be advised on the party's right of appeal. The ruling and decision shall be issued by the Bureau within 30 days from the submission of the necessary document and information. Section 114. Right of appeal, forms, and ground. Any party adversely affected by a decision or omission of the Bureau pertaining to an importation, exportation, or any other legal claim shall have the right to appeal within 15 days from receipt of the question, decisions, or order. An appeal in writing shall be filed with a period prescribed in this Act or by regulation and shall specify the grounds thereof. The Bureau may allow a reasonable time for the submission of supporting evidence of the appeal.